There's been a lot of confusion regarding the statement of birth record and the birth certificate. So I just want to just clarify so you understand the documents. They may be called different things in different states or provinces, but pretty much the documents that I'll be referring to will make sense when you look into it. The statement of birth record is what your parents filled in at the hospital. So whatever document your parents filled in regarding given name and last name or surname is what we're talking about as far as the statement of birth record. In the province of Ontario, that's Canada, that's referred to as the Form 2 in the Vital Statistics Act. So that's what the parents fill in at the hospital. The doctors fill in the Form 1, which has no given name of the child at that stage because it hasn't reached that level yet. The first thing that brings the child or the privacy of the child into the record is based on the filing or the document that the parents fill at the hospital directly. Do not confuse it with the birth certificate, because the birth certificate is not the statement of birth record. They are not one and the same. What the parents fill at the hospital and what you receive as a birth certificate are two separate things. The birth certificate is an extract or taken from a document you've never seen. So just consider it like the key ownership document that the state holds in a separate. This is an extract from that. They use what the doctor fills in, they use the record that the parents fill in to make a birth certificate, but that's where it gets very unclear and ambiguous. The state is asking for something that doesn't belong to them, so to cover the legality part, that they haven't violated anything, they leave the birth certificate as unclear and ambiguous. We call it a latent ambiguity. You wouldn't see it on the face because they didn't run out of ink not putting given name or surname or given name family name or given name last name on this document. They just left it that way unclear in order that they didn't cross the line, because they have no right to the privacy of the child's given name, because a child could never consent to enter into contract law, which citizenship is, because it requires duties, debts, and obligations to be fulfilled, and a child could never participate in that because they're not at an age to participate in a contract. So they're anything that would even imply that they have a contract with the state is actually void, and then later voidable if they entered in. So now we go to basically a question that's been asked numerous times is, do I need to fill in the birth registration document for my child? And I would say, well, there's certainly some things belong to Caesar and some things do not. Clearly, the scripture said, render unto Caesar what is Caesar's and to God what is God's. So the given name does not belong to Caesar. That's private. Private means, in its real true meaning, out of the dictionaries, even if you just go to an English dictionary, means not belonging to the state. So it doesn't belong to the state because the child couldn't enter into a contract with the state as a minor. But the surname belongs to the state. And because the parents are participating in the legal citizenship contract, and they've already got their names exposed and merged together in the contract, well, it doesn't give them the authority to place the given name really down on the record, but many have done that. And that's really a mistake to an extent, but it still hasn't harmed the child. In essence, it's just inducing the participation more fully. So Caesar only requires the surname, because you'll notice that's all that's ever used, whether in court of law, you're always referred to as Mr. with the last name. They don't really require to speak to you in the given name. So the given name, if it was not placed on there, would not be causing a problem, just maybe simply not applicable, unknown. I would probably leave it in more as not applicable, because unknown, you really do know the name, you're just not placing it there. So it'd be much more truthful to put not applicable. And therefore, Section 9 in at least the Ontario Vital Statistics has the scenario of a parent or a guardian or whoever was looking after the child that decided not to put the given name on the record, and it left the option that when the child reached age of election, 18 roughly, that they would be able to elect or choose to put their given name into the system and then pay the appropriate fee and receive a birth certificate. The record that was originally filled out that didn't have that most likely would never have the given name in there unless they would create another second statement of birth record and close off the old one and then have that evidence that the given name is on there now. But I would believe more so that it's just to obtain the birth certificate. And so therefore, without having a given name, you're not going to function in there. So therefore, there would be no purpose without that merger. So the given name is just really an evidence of consent to take on the other name that is registered after birth. So we have to be clear on the subject. The surname is registered after birth, after acquired property, has nothing to do with the given name. The given name is actually the property, your proper name, and therefore that is yours. And that's what the child has the ability later to decide to put on there. So let's just leave it at that. There's enough law case behind that, and if you need more on that, we may touch upon that subject in another video.